Hello, everyone. Welcome to Facebook this week. I have here with me Rylan, and I think Jennifer might be joining us in a bit, unless she's gotten distracted with other news. But anyways, I wanted to get started and talk to you all about what's going on in the world of immigration today. So Ryland, why don't you help us out and tell us about what you want to talk about today?
Yeah, so I saw that there was a reminder put out by it was either AILA or USCIS or both about the Liberian Refugee Immigration Fairness Program. So this is a program where if you are a national of Liberia and you have been in the United States from November 20th of 2014 to today, and you are admissible, meaning that you don't have any criminal bars or you don't have any unlawful presence, but there is, if you are eligible for a waiver of one of those bars, then you could still apply for this program. So if you have all of those aspects, then you can apply for a green card through this program. However, this program is only available until this December 20th of 2021. And so since that's coming up in 4 months here, I wanted to give a reminder to anybody that could possibly be eligible for this program to reach out and get in touch with our law firm or any law firm to try to get their application submitted before that date, because it's a really good opportunity if you are eligible to get a green card and you don't have another pathway to that green card. So yeah, that's my update for this week.
All right. Well, I know that Jennifer wants to talk about the reinstatement of the MPP program, the Remain in Mexico program, and so hopefully we will have her join us in a bit. But I want to talk about something that is literally right off the presses, hot off the presses just today. And that is that there is a nationwide injunction. Well, let me back up a minute. So one of the President Biden's jobs is to be literally the chief police officer for the entire country, right? He is literally the nation's #1 executive police officer. And as any police officer, he has to decide priorities of whom he's going to arrest, whom he's going to place as a priority for purposes of immigration. And every president, from Trump to Obama to Clinton to all the way down, has done the same thing. When they've come into power, they have decided what their priorities are going to be with regard to enforcement of the laws. And by enforcement, I mean, who are they going to arrest? Who are they going to put in jail? Who are they going to seek to deport? All of these are enforcement priorities. Well, when President Biden came into power, he replaced President Trump's enforcement priorities, which was basically anyone who is here undocumented, regardless of status, with a new enforcement priority that is much broader. And basically, unless you're an aggravated felon or a recent entrant, then you're not considered an enforcement priority. So the news is that, we were seeing a lot of movement with regard to the immigration courts being very aggressive about giving clients prosecutorial discretion, terminating removal proceedings, granting administrative closure. We've seen Immigration and Customs Enforcement granting stays of removal, granting deferred departure, stipulating to different forms of relief in removal, such as cancellation or hardship. So we've really seen those enforcement priorities come into play very quickly. But as of today, Judge Tipton in a district court order issued a nationwide injunction over those enforcement priorities. What that means is that the enforcement priorities no longer exist. And I assume that we go back to the enforcement priorities that were in play during the Trump administration, which is that everyone is an enforcement priority. So stay tuned, because I am sure that there will be further litigation on this issue. But for now, everyone's an enforcement priority. Now, what I think will happen from here is that this will get appealed to a higher court, a circuit court, and that they will seek an emergency stay of the injunction during the time so that the enforcement priorities are put back into play. But that's my call for it. But stay tuned for further updates on what's going on with this. All right, Jennifer joined us, so let's go back to Jennifer. I know that you wanted to talk a little bit about the Remain in Mexico program, so give us an update on that.
Yeah, some more fantastic news. Last week on the 13th, a Texas district judge issued another injunction directing the Biden administration to reinstate what's more formally known as the Migration Protection Protocols and more informally known as the Remain in Mexico program. This was a policy that Trump started to require asylum seekers to wait in Mexico for their asylum hearings. And this is problematic for a lot of reasons, but basically the border areas that they were having people wait in Mexico are extremely dangerous. And these people are already coming from dangerous situations. And then there's reports of them being targeted for additional crime, sexual assault, all sorts of personal violations while they're waiting in Mexico. So this is just like even more of an assault on asylees, on the asylum program at a time when we should be, welcoming refugees and asylees. So the Biden administration is expected to appeal the decision though. And the decision's saved for 7 days, so we should see an appeal pretty soon.
Awesome.
Yeah.
Well, and what I think personally is the biggest news of the week is the big victory that we shared with a number of other people in the Gomez-Aker lawsuit for DV2020. On Tuesday evening, August 17th, Judge Mehta in the United States District Court for DC ordered the Biden administration, the Department of State, to issue the 9,095 diversity visas from DV2020 that he had previously reserved because he assumed that this would happen, right? That his decision might ultimately decide that it was unlawful to decide that, well, let me back up a minute. What the case was challenging in Gomez first, and then our decision by our firm and Cook and Baxter and Siskin and Susser from Impact Litigation, is it was a challenge to the Trump administration to decide to use a statute called 212F. And 212F says that the president has the ability to basically say, we don't want these people to enter the country. And by these people, I mean any class of people. And President Trump used that authority broadly to try and ban Muslims from the United States, to try and ban people under public charge grounds from coming into the United States, and other grounds. And during COVID, what President did is expanded or tried to expand this 212F authority, not only to restrict entry into the country, but to say to the consulates, now you not only am I going to restrict entry, but you can't even issue visas to people no more. And so there were a number of bans that came out, proclamations that basically banned different types of visas around the world, including immigrant visas and non-immigrant visas. So there was a lawsuit called Gomez that was filed, that was drawn to Judge Mehta, and that lawsuit was filed by a coalition of the American Immigration Lawyers Association, headed up by Jesse Bless, who's the litigation director there. The Justice Action Center, who is their legal director is Esther Sung, and the Innovation Law Lab, who deputy legal director is Tess Helgren. And they worked together to file a massive challenge to this lawsuit. Simultaneously with that, we determined that this would particularly impact diversity visa applicants, right? Because unlike other immigrant visa applicants who could wait forever for their visas, diversity visa applicants really have 1 year, sort of a race to get those visas. And if they don't get them in that year, they go away. So Trump's visa ban had particular detrimental effect to diversity visa applicants. And that was the lawsuit that Impact Litigation filed on behalf of DV 2020 applicants. And that was the case of Aker. And you've heard about that, speak about that before. So what ended up happening is those lawsuits were all consolidated. Aker was consolidated with Gomez, and there were a number of other lawsuits consolidated with Gomez. So there were actually several lawyers, several groups of lawyers working together on this case. And the first thing that we did is file a preliminary injunction. We said to Judge Mehta, you really have to do something about this right now. And that was filed early on in the lawsuit. And what Judge Mehta did in that case is he basically parsed out the preliminary injunction. And he said, I'm not going to grant the preliminary injunction for all of the visas and all of the non-immigrant visas. I don't think that you've proven, what you need to get a preliminary injunction. But I do think that you've shown irreparable harm for the diversity visa applicants. And so for the diversity visa applicants, I am gonna grant them relief. And I'm gonna reserve, through a very complicated formula, he reserved 9,095 visas for those diversity visa winners. And so that was a huge victory for our plaintiffs, the Acre plaintiffs, because that was our class of plaintiffs that had asked for that form of relief. Unfortunately, the Department of State did nothing on those visas in the past year. And so there, DV 2020, remained, unfortunately, detrimentally affected by this. So on the 17th, the Judge Mehta finally issued his decision on the summary judgment, granting in favor of the plaintiffs on the relief we were seeking, and finally ordering the Department of State to issue those visas. So what does that mean for all of the DV 2020 winners around the world? We are in the process of determining that right now. I can tell you that the legal team has already been contacted by the government and asked the questions of, like, how are we gonna, what do we propose and what date do we propose for resolution of these 9,000 visas? And out of respect for my colleagues who are also litigating this issue and our co-counsel on this issue, I'm not going to get into the details of what we're asking for. But I will tell you that all the unanswered questions, those unanswered questions about, what happens if consulates are closed, this is our opportunity to sort of craft those questions for the government. And that's what we're in the process of doing right now. And we should know very quickly and very soon, because the court has ordered us to report back, I believe by 2 p.m. today, Eastern time, which was 12 minutes ago, what the process is. So stay tuned. What dates we have our live podcast, both for Impact and for Joseph and Hall. So stay tuned for Facebook, and we will be in touch with you about what's those further updates as we get through. So good news for Gomez Acre. And also I want to say this bodes very well for Go as well. The judge is basically saying, yes, I think this was unlawful. So it doesn't seem to make sense that it would be unlawful in one year, but not unlawful in another year. There are differences in the Go plaintiff case and the Acre case, but I do think that for DV 2021, it does look very good for the Go plaintiffs. Now, one thing I will say about the decision is that there was no relief specific for named plaintiffs. The judge did not go so far as to say, I'm going to prioritize named plaintiffs. So now, our plaintiff class, our Acre plaintiff class, of all of our plaintiffs, I think all but one was granted their visas. The problem is that Acre was consolidated with other cases who had literally thousands and thousands and thousands of cases. And so I think that the judge may have had pause about saying, just because you file a massive lawsuit doesn't mean that I'm going to give you priority. I also wonder, whether the judge is trying to push class actions in cases like this rather than massive lawsuits, because it requires a lot of discovery. It requires a lot more documentation, potentially, to do a mass action like this in terms of declarations, et cetera, than to do a class action. And on the other hand, the government has pushed back against nationwide class actions. So plaintiffs are in this stuck position about, do we push class actions, knowing that issue is not in favor at the Supreme Court, nationwide class actions, and also knowing that there'd be litigation, or do we file, mass actions, knowing that the courts they don't love it. So it's a strategic decision, and one that we stand by our strategic decision to do it as a mass action. So anyways, let's see if we have any questions today. Let's go to, first one is, when will we have a decision in Kinsley? I wish I could tell you, but here's what I will tell you. The decision in Gomez equally bodes well for the decision in Kinsley, because it's also challenging, the same idea that 212F, the statute, is being unlawfully used to ban basically the issuance of visas. So it does bode very well for Kinsley as well. So Judge The judge now has a decision to draw from as precedent, not as precedent, because two district court judges in the same court have equal authority, but it is what we call persuasive authority. So, what one judge feels about an issue and who is the first judge to rule on it is persuasive about how another judge would rule on it. So I think we'll have a decision soon. But as far as the date, just like all other decisions, it's like, predicting, I don't know, what's something we can't predict? The day when you're pregnant, the day your baby's going to be born, right? You just can't predict it, right? It's going to happen when it happens. I don't have any control over it. So, all right, let's see. Hello, folks. Thanks for all your efforts. K1 Manila, does the Aker-Gomez win or impact the case at all? What do you all think? Jennifer, Ryland, does Gomez have any impact on K1 Manila?
I mean, I think we're looking at a very similar situation that these visas that should have been processed were not processed, and it was in the name of protecting the country because of COVID and following the presidential proclamation. So I think it is a good thing. It pushes Manila to be more likely to be successful, because we can see, well, they're doing the same thing for diversity visa lottos, and that is not even the K1s should possibly have more priority than even those, because they are the fiancés of a U.S. citizen, and that should have been not even subject to the proclamation. That is something that we're talking about and has been fought over in the briefs, and we realized through looking through the government documents that they are trying to make exceptions for the K1. So I think that it is a good thing for the K1 Manila.
Jennifer, anything to add to that?
No, I think that sounds good.
Yeah, I mean, the thing that I would add is that well, first of all, they are two different classes, right? So one is DV2020 and the other is K1s, right? So I would say the differences are the harms for DV 2020 are more significant, I might say, than K1s, because those visas go away, right? So in terms of the harm, I think that's stronger. Now, I could make the same argument if I'm a lawyer, which I am, for K1s, right? Just like Ryland just did, right? Because the government has said, regardless, DV is much lower priority than K1. So who is a court to intervene and say DV should be placed higher just because of the harm, right? I could make the argument that court, you shouldn't intervene. K1 should be priority because you've already said that, and you shouldn't interfere with what the Department of State is doing in terms of prioritization. So you see how I, as a government lawyer or as a defense lawyer, can make two different arguments for the same thing, right? So will it impact it? Yeah, if I'm defending you, but no, if the government is defending their client. The other thing that I would say is that one is a challenge to a proclamation and the other is mandamus, right? And so you've got two different issues there as well. Now, the judge did say in Gomez that we win on the mandamus claim, because the refusal to adjudicate cases is essentially an unlawful withholding of adjudication, which is you can remedy through court, and so that was, the judge found that was true. So the same argument could be made in the Manila case, that we think it's an unreasonable delay, right? The government's gonna come back and say but COVID trumps all, and our argument is okay, fine. COVID may trump unreasonable delay, but it doesn't trump, we're just not issuing visas, period, full stop, regardless. So I think those are two different issues, and a court does not have the authority to say no visas, because that's essentially taking the proclamation as a visa ban. It's no different than a visa ban. So I think it bodes well if I'm defending you. I think there's arguments I could definitely make if I were for the government. So stay tuned. That's why you have us as your lawyers. All right, next one. Michael, have you been able to talk to Mr. Carrillo about round 2 Milligan plaintiffs vis-a-vis Ramirez? So here's the issue, Michael, is that I'm having Luke, who I think you all have met before, one of the attorneys that's in impact. I'm having him go through the spreadsheets from round 1, round 2, and we know there's no round 3 plaintiffs from Manila, but having him go through round 1, round 2, and then Ramirez, and parsing out the ones that have been interviewed and not interviewed, and trying to figure out if there's any rhyme or reason to the formulas, right? The dates of being qualified and all of these things, to see so we can have some information to go to Joe and say, we think these classes of people are being treated inconsistently. So Luke did send me the first draft of that email yesterday, and I have not had a chance to review it, but I promise you that as soon as I do, I will send it to him. But that's why it's taking longer than I thought. So you have an explanation there. Okay, did you notice that Judge Mehta denied the mandamus part of DV2020 lawsuit? No, I don't think that's necessarily true. I think he said he's not going to interfere in the idea of whether the government is processing things in any particular manner, right? He was saying, I'm not going to get in, but to the extent that they're not processing things at all. In other words, I told you there's these 9,000 visas and you have done nothing in a year, then that is an unlawful withholding of an order that he put into place, right? So that was the basis of his mandamus claim, is I ordered you to do something which you failed to do. So I think it was granted partially under mandamus. Maybe not mandamus, but API. I actually did not look to see whether it was granted under mandamus or APA, but I can look back at that. Same relief, different statute, in other words. If we look at this part of the order, the court appreciates that the named plaintiffs had made additional efforts by filing suits, but is bound to respect Congress's decision that the processing of DV proceed in a random order, and the court will not order defendants to prioritize certain DV applicants over other class members. What do you think? Can that impact go? So this doesn't have to do with mandamus. This has to do with class certification, right? So the idea here is that just because you're a named plaintiff does not mean that I'm going to give you priority for those 9,000 visas, specifically because it's not a class action. So what the judge is saying is that, yes, I think the government has to issue these 9,000 visas, but you don't get priority because you filed a lawsuit. Do I think that will impact go? If I had to guess, to be honest, I do think it will. And we will have to deal with that when it happens. But I anticipate that the judge's order will be very similar to go. Now, the only difference is that the go plaintiffs filed this lawsuit way, way, way early on in the fiscal year. So that's the only distinction that we intend on making to the court, is that, the reason that we filed this lawsuit on for these particular plaintiffs is early on is because we knew this was going to happen. So that's the difference in just random lawsuits about, but we will cross that bridge when it comes. But as your lawyer, if you're asking my opinion, yes, I think it will impact go, and I anticipate the decision will be very similar. Let's see. Jeff, have you been in contact with the lawyers for that? Yes, Jason, on your particular case, I have been in contact with Joe. I don't know if you have received a response. I'm not sure if I've been in touch with him more than one time, but I will look back in the emails and find out when was the last time I contacted him. But I do know that it's been at least one time that I've contacted Joe on your case. About the other ones in Manila Round 2, I think I answered that up above. We are in the process of dealing with trying to figure out where, how many prospects out of Milligan Round 1 and Round 2 versus Ramirez to see why there's disparate treatment. Okay, I-140 EB Online status says RFE and RFIE issued on the same day. Still waiting to get in the mail, but why two at the same time, and what does this may mean? So request for evidence and a request for initial evidence. So the difference is this is actually a really interesting question, is that the regulation provides for two different types of RFEs, an RFE for evidence, additional evidence, or an RFE for initial evidence. Okay, initial evidence means evidence that should have been submitted with the initial application. And you can actually, in addition to an RFIE, you could actually get a notice of intent to deny instead of an RFIE, which is, we are going to deny this petition because the evidence you failed to submit actually goes to eligibility, right? So in this case, it's probably the evidence that you failed to submit is probably not to eligibility, but it is to adjudication. In other words, they can't adjudicate the case unless you provide this initial evidence. So it's possible that your request for evidence is, for example, we don't think you're a manager, send us proof of your managerial authority, right? Your executive capacity. And the request for initial evidence is you never submitted a copy of your previous I-94 card. Without that, we can't grant your change of status. So that's what I'm guessing is that this is actually legit and you have an RFE and an RFIE. And the other thing is I don't recall, but I think they have two different timelines. So if you're responding to an RFIE, I believe that it's 30 days that you have to respond. If you're responding to an RFE, it's 87 days to respond, plus the COVID extensions, blah, blah, blah. You all know about that. Or if you don't, ask your lawyer or ask us. But the general rule is 87 days for RFE. I think 30 days for RFIE. All right. Do I think the judge is going to issue an order for the GO lawsuit by the end of this week? Well, for all of you out there in Facebook land listening, we are having a contest, and you can send an email to Ryland with the date and time that you think Judge Mehta is going to issue the GO decision. And hint, hint, I think it's going to be sooner rather than later. And the winner, the one that comes closest, Ryland will pick, and we will send you a beautiful impact litigation mug free of charge. So
I appreciate that.
Ryland, RYLAND. Let me say that again, RYLAND @immigrationissues.com. And we will boost that email address as well to make sure that everyone gets a chance.
Do you have a terms and conditions statement you have to say after that?
All right. Let's see. What do we hear? Thank you, folks, for being informative. We love to be informative because when we are more informative, when we're more informative, our clients are more informed, they make better informed decisions, right? And the more informed you are, the better we are able to do our job. So actually, we love it. And we love when you come and ask really, really great questions that help other people. Do you think the judge will issue one order for GO together with other DV21 lawsuits that request PI? Okay, again, it's tea leaves here. I do think he's going to issue one decision because it's more efficient, right? I think the issues are sufficient enough at oral argument that, yes, I think that he will issue one consolidated decision. Will he consolidate the cases? I don't know, but I think there will be a consolidated decision. And I think that was how it happened in Gomez, right? The first decision was for Gomez, and then was the second decision for the other plaintiffs? Was that how he did it, or can't recall?
Yeah, I think that's right, but
okay.
I'm not sure either.
All right. Let's see. What are the chances that the qualified plaintiffs of GO get their interviews by the end of September? I would say close to zero. There will be some of you that definitely do. In fact, we know that some of you have already been granted your visas, but all of you, no, it won't happen by the end of September. That is why we are asking in a preliminary injunction for the judge to reserve numbers. And the judge has the authority to do that, and he did that in the Gomez case. So if the judge grants the same relief in GO, then it won't matter whether you get your interview by the end of September or not, because the visas will carry over until the other fiscal year. And they'll be reserved. So if the relief is the same. Now, it could be that the judge says, no, I'm going to reserve this number of visas, and you have until September 30th to adjudicate them. But here we are, it's August 19th. I don't think that will happen. I think the judge is just going to say, here's how many you should have adjudicated in this time, like you did in Gomez. And now you have this period of time to do that. And so I don't think it will matter whether you get your interview by September if we win. All right, Ramirez has some plaintiffs over 700 days since filing. Yes, I know that. Yes, we're very well aware of that. And we know that's why we're going through the spreadsheet to see if we can find any rhyme or reason for, well, first of all, is it really first in, first out? And if it is first in, first out, what's the date of the in that they're using? We really don't know. Is it the date that all the documents get in? Is it the date it's sent to the consulate? Is it the date that gets at the KCC? Is it the I-129F date? We don't know what the in date is. So when it gets to that final point and everything's done, what are they determining when they set the interview? Is it filed first at the very first initial stage, or what? So so that's what we're trying to determine before we go to Joe to say, we think people are being treated differently. All right, do you think if the judge rules to save visas, that we'll be getting the priority to Good Luck's case? I'm imagining GL's Good Luck's case plaintiffs, since there are so many of them. Thank you. I think actually no, I don't think so. I think what Judge Mehta's, this is my personal opinion. This is not based on legal authority whatsoever. But at oral argument, the question came up, why did you not file this as a class? And there really wasn't a Good Luck attorney did not have a really good answer for that, right? And so I do think that there's some concern for the judge of that it's not fair to grant relief to people ahead of 9,000 other people just because they filed a lawsuit. That's my guess. Now, if we'd filed this as a class action, okay, the judge may have been more inclined to say, I don't know, the judge may have been more inclined to say named plaintiffs get relief first, right? Because then there's no reward for doing it. You did it on the benefit of everyone, but you get relief. I don't know. It's a judgment call again. The argument on the other side that I would make if I were me as a lawyer defending you is that class actions are dangerous because the Supreme Court hates them, and nationwide injunctions are very much disfavored. And at some point, I think, if you ask me, I think the Supreme Court's going to overrule nationwide injunctions. And so courts are very loath to grant them. They hate granting them because of litigation. And frankly, we don't like litigating them. We don't want to add an additional issue to winning the case of is this a justifiable class or not? Because to win a class, you have to show a lot. You have to show that there's, sufficient numbers, which is easy in DV20. You have to show that there's commonality. You have to show that everyone is similarly situated legally, which is difficult because all of you have different numbers, right? It becomes very difficult to nail down a class, and the government can litigate that forever and prevent a decision. So if we're getting paid by individual plaintiffs, it is to the plaintiff's advantage for us not to do a class in most cases, right? But now I think we're seeing the court sort of react to that because, Judge Mehta, I think, frankly, was very shocked at the number of plaintiffs brought to him in his case. I don't think they're used to seeing that. And, so maybe this is the counterbalance to this whole, disfavored status of class actions is okay. Well, if you don't like class actions, then accept mass actions. I don't know. We'll see. But that's where I think if you ask me where I think this is all coming from. So let's see. Any other questions? Thanks for the explanation. I prepared a declaration where you showed how it's manipulating numbers and receipt dates. Yes, I know that. I think that is what part of what Luke is using, as well as the self-reported information from plaintiffs. So thank you. All right, plaintiff prioritization. If the decision in Go is similar to the Gomez decision, how does summary judgment help us? Can you elaborate more? My guess is that Go decision will come tomorrow, and I live in Virginia. Okay, so how will summary judgment help you? Because if we win summary judgment, then the judge is essentially saying you win the case, right? And when we win, then the judge has to grant us relief. In other words, the judge has to do something for us if we win. And we have asked the judge for specific types of relief. And I can tell you that the specific types of relief that we've asked for are that either the judge reserves numbers past September 30th so that DV 2020 applicants or DV 2021 applicants who have numbers can still apply after September 30th. That's the relief we're asking for, which if he does what he did in Gomez, would mean that there would be a significant number of visas reserved past September 30th, okay? Or alternatively, we've asked the judge to reserve numbers as of the date of the filing of the 485 or the DS-20, whatever immigrant visa application or whatever application would have put you in the queue to allow you to preserve the number as of that date prior to September 30th. So I don't know how the judge is going to rule. We will see. But if he rules like he did in Go, then it will benefit a large number of people. Will it benefit you individually? In other words, will the government give you priority? Probably not. If we base the decision on on Gomez, then probably not. The judge is not going to give you priority as a named plaintiff. If you ask my opinion. So let's see, if we get the reserve, will they start 2 NLs based on case numbers or a random way? Great question. So one of the advantages to winning this Gomez case, as I set up above, is that we now get to ask these kind of questions to KCC and to the DOS. And so that's what we are in the process of drafting, or it has been drafted by the class of attorneys in Gomez, is these kind of questions to Department of State about, how are they going to reserve the visas and what's the process for doing that? And frankly, what happens at KCC? Can we open up a channel of communication, which has been one of the things that's been most frustrating through this process, is just the emails that are non-responsive, right? So what we hope is that there will be a line of communication open with KCC for people around the world to actually ask questions and find out, the status of their case. So I'm going to end it there. I think that's good for today. Do you all have anything anything that sparked your attention that we've talked about so far?
Yeah, well, it was something that we just didn't discuss, but I did want to note that everybody in the office is paying attention to the situation in Afghanistan. We're all, it's been a scramble, and people are trying to figure out the best way to help people that are stuck there and help the people that want to get out. And so we're paying attention to all the information that we're getting, and we're gathering it all together for if people are coming to our office to see if there's somehow that they can help family members that are stuck there. We're trying to figure it out as well. So
actually, can you just keep talking for a minute?
Yeah.
Because I'm going to actually give everybody a link to a resource page,
okay,
or where you can go to help out. So if you can just give me 2 seconds and keep talking.
Yeah, and I also saw that there was an email that was sent out today that it was from, I'm trying to see now too, but I know that there's an email and it's actf@state.gov. And that's if you or a family member or a colleague require emergency evacuation from Afghanistan, you send an email to that email address, actf@state.gov. Include a copy of your passport page with the photo and any other identification documents. Explain why you're at risk at this moment and how many immediate family members are included in that risk assessment. And make sure to give your email and mobile phone number in Kabul. And so that is an email address that was sent out to me from our other associate attorney, Zach. I'm not entirely sure where that came from, but I know it's adding people to a list to potentially help get them evacuated from Afghanistan.
And you can see I just posted that there on the banner, Rylan, so everyone can see it.
Yes.
The other one, I hope this is accessible to the public, but I'm going to put here some resources from AILA, our bar association, for dealing with Afghanistan, people from Afghanistan as well. It has a lot of information. So please feel free to cut and paste this as well. So All right, you all, thank you. And we will be, and by the way, if you know somebody that needs help in Afghanistan, there is a legal process for parole. So if you know someone that needs help, we are here to help them. So please do have them contact, because there's legal opportunities as well for people. Thank you. And we will see you next week. Bye-bye.
Bye.